following program on Other Derana 24 is classified for general audience. It is intended for all ages. It contains little or no violence, no strong language, and little or no sexual dialogue or situations.
Tonight, we discuss the rudiments that govern the customs law in Sri Lanka. The control of the gateway through which a variety of commodities enter a country is governed via the customs authority. Regulations exist to ensure social protection and the collection of revenue, which has continued to be an essential service. What are the key areas through which the law that governs the customs authority needs to improve over time? Does the customs ordinance cover the requirements that have arisen in the 21st century? What are the loopholes in the current structure that needs to be addressed? Alright, welcome to Law, Land and Liberty. We're keeping with the promise of bringing in a contemporary legal topic and breaking it down for our viewers. Now, as usual, when you follow this program, you'd have noticed that based on what's happening within the country, we have tried to keep it relevant to the most interesting and the most contemporary topics, as we mentioned. And something that has come up with regards to the country's current situation is the laws that govern the trade that happens within this country. And the conversation on trade has increased massively over time, given the fact that there is a foreign exchange issue, currency issue within the country. And the capacity for trade is something that we have to improve on as a nation totally. So in that subject, we believe that the customs law is something that really needs to be ironed out both for the laymen and the law students who are coming into this area, because there is a huge push towards alternate methods of dispute resolution within this country also, and that is the trend that the world is going towards. And to give a breakdown of all of this, we have with us Attorney-at-law Tivanka Ekaratne. Thank you so much, sir, for joining me on this program. We are going to talk a lot about exactly the areas that you have been writing on and exactly the areas you have been practicing on. So it will be a very good experience for us as well to speak to a practitioner in this area. He was the former president of the Colombo Law Society. He's a leading practitioner in the field of customs law. A lot of interesting things that we'll have to cover. Now, as usual, what we do within this program is we give our viewers a breakdown of what we are going to talk about within each segment so that it is easy for the viewers to follow what we'll be saying. Firstly, we'll talk about the principal statutes that govern the customs law. Secondly, the application of customs duty. Thirdly, the laws on illegal imports and other crimes. And finally, we'll talk a bit about the remedies and potential reforms that are required in this field. All right, let's get into the discussion directly. Thank you once again, Mr. Tivanka Ekaratne, for joining me on this program. I really want to pick your brain on a lot of things pertaining to this specific field now that it's affecting almost everyone within this country. Firstly, when we take the issue of the customs law and the entire issue of bringing in commodities within the country and exporting it either and even through immigration and whatever you're bringing in your hands, the most basic things are being governed by this specific field. You're also an author within this field. You have certainly had a wide amount of experience handling cases within this field. So my first question to you is, for the layman, for the law students who are watching, how do you enter this topic? What are the main statutes? What are the key principal pieces of law that we need to be aware of when focusing on this area?
Tanindu, customs law is a very vast area. Given the area, I would answer in the most simplest way so that the viewers would understand this area of law. Yeah. Customs law regulates imports and exports of a country. Any person who wants to import or exports any goods from one country to another, it is the duty of the customs department to enforce such control and to collect the due taxes imposed on goods. The main statute which governs the customs law is the Customs Ordinance Act number 17 of 1869. Right. This is I would say, a comprehensive piece of legislation with 167 sections, which covers the entirety of the customs law in Sri Lanka. Customs ordinance speaks of everything except the customs inquiry procedure, which we'll be talking about in a later segment.
Yeah.
Other than that, everything is basically in one piece of legislation.
Right.
However, apart from the customs ordinance, there are certain other enactments which governs customs law. Say, for example, any person who is importing restricted goods, that is restricted, you can't bring it.
Yeah.
But there are under certain licenses, you can import restricted goods. So you need to go to the Controller Import and Export and obtain a license so that you can import that restricted goods. So the Import and Export Control Act number 1 of 1969 comes into operation.
Right.
Further, there is, for example, if there is foreign exchange involved, say for example, one party is importing some goods from China to Sri Lanka. If the payment is made through a foreign currency account, then the Foreign Exchange Act comes into operation, Act number 12 of 2017. Further, there is Intellectual Property Act. For example, if the goods are exported from Sri Lanka, any country that the goods go to, they will expect a certificate of origin which says the goods have been originated from Sri Lanka.
Right.
In such a case, that party is expected to go to the National Chamber of Commerce and obtain a certificate of origin from that department. And apart from that, there is Port Authority Act, Revenue Protection Act, Monetary Law Act. Those are the acts that governs customs law in Sri Lanka.
Right. So as you explain, I think we get a clear picture of, there's multiple legislation that governs this specific area apart from the key ordinance. I want to ask you about those specific areas also, because for most people this will be another sort of experience. We see there is very little clarity amongst the local individuals who are generally not exposed to the entire trade industry. If you just focus on the customs ordinance, in order to explain this entire process, what are the key sections that people need to be aware of and people need to sort of understand? This is based on, I want to ask this based on your experiences also. What on a daily basis do you see as cases that come up within this field? Where are the contentious areas? I think that will give us a lot of clarity into this.
Yes. Tanidu, customs ordinance, the main section that is dealt every day is section 8.1 of the customs ordinance. It is under section 8.1 of the customs ordinance that inquiries are conducted. Customs inquiries, in my interpretation, I would call it a quasi-judicial inquiry. It is not a judge who sits. It is a customs officer in the rank of Deputy Director of Customs. However, it is like a courthouse where there is a prosecution, where there is defense counsel, and there are suspects. So at the customs inquiry, usually the evidence against the suspect is initially led by the prosecuting officer, who is called the officer assisting the inquiry, and the defense is given an opportunity to cross-examine the witness, and likewise thereafter the evidence of the witnesses are led. However, the difference in a court case and the customs inquiries, unlike in the court case, the charges are not framed at the beginning of the inquiry. However, at the end of the customs inquiry, the honorable inquiring officer will frame charges, and thereafter, when the charges are framed, the defense is given an opportunity to show cause as to why those charges should not be continued, and nor the relevant specified penalty should not be imposed. So that is one section. Apart from that, there is sections which dealt with regard to valuation in the customs ordinance. There are schedules which deals about restricted goods, prohibited goods, etc. And there are sections to deal with the law, that bail, that is section 127, which specifies where and how bail can be granted in a situation where customs offence is committed, and also there is section 146 which sets out if at the inquiry, customs inquiry, if penalty imposed is not paid, how and where customs officers should go to and initiate a case. Apart from that, there is also sections in the customs ordinance, section 163, where the general public should know, in the event if there is any penalty imposed, they can always go to the Director General of Customs under section 163 of the customs ordinance and lodge an appeal. And even if they are not happy, still they can go to the Minister of Finance under section 164 of the customs ordinance, where the minister has a vast power to even reinstate whatever the penalty and the goods back to them.
Right.
So those are the key sections that would be dealt, that the general public should be aware as regards to the law.
Right. A minor clarification I want to make on that, Ms. Tivanka, is what you suggest is there is no sort of the court proceedings as in a general, either to a magistrate court or to a commercial high court, there is no transference within this case. It will primarily be dealt, as in like issues will be dealt with either by Deputy Director of Customs or within that hierarchy. Is that how generally it functions?
Yes, Danidu. Initially, it is mandatory to, after completion of investigation, there is investigations and inquiry. As per section 7.1 of the Manual of Procedure, an inquiry commences only after completion of investigation. So first, the customs officers have to complete their investigations, and upon completion, they have to conduct a customs inquiry under section 8.1 of the customs ordinance, and only at the conclusion of the customs inquiry, if the penalty is not paid,
right,
then they can recourse to the usual courts. However, the difference in the customs ordinance to other acts or ordinance in Sri Lanka is, at the end of the customs inquiry, if the penalty that is imposed is paid by the particular person, the suspect, he remains a suspect and he will not become an accused.
Okay.
Because the whole purpose of customs law is to collect revenue which is due to government.
Right.
If the due penalty is not paid, then there is provisions to go before the magistrate, which we will deal later at a segment, and recover the money. And also the citizens or the litigants, they have a right to go against the order by way of certain other things, which we will discuss again, to the certain courts, seeking relief against the order of the inquiry, customs inquiry.
Right. I think you've established the basics when it comes to this specific area. I think that gives a lot of clarity even to me. One thing I want to ask you before we go in for a break, Ms. Tivanka, is now you did list out other pieces of legislation, and you mentioned these are also very much attached part and parcel of this entire process. Anything that you would like to mention with regards to those those areas? Are there key sort of like legislation, either the Foreign Exchange or Foreign Exchange Act or anything of that regards, where there are questionable areas, where there are contentious areas, where there are constant issues that arise? What are the key provisions that people need to be aware of, apart from the customs ordinance, that is?
Yes, mainly the Import and Export Control Act and the Foreign Exchange Act.
Right.
So one should realize, unlike in other countries, these Import and Export Control and Foreign Exchange Act, these tend to change every day.
Right.
Sometimes I would say overnight. So it is with the power vested upon them by way of gazette notification, they change.
Yeah.
Sometimes the goods items change, sometimes the amounts change. So now, for example, some time back, the foreign currency that any person could take out of the country or into the country was 10,000, any currency equivalent to US dollars 10,000. So now they have increased it to 15,000, whereas any currency that is equivalent to that particular amount, you can take or bring without declaring to customs. However, if you bring anything more than that, you are supposed to declare to Sri Lanka Customs. So likewise, these tend to change by way of gazette notice. So people should be aware, and they should have some recourse, some access to these statutes, at least consult some lawyer or any officer who is known to them before indulging in whatever the transactions they are doing.
Right. I think that gives a certain clarity in terms of where this discussion will go from this point onwards. We'll take a very short break. We're in conversation with Attorney-at-law Tivanka Ekaratne, and we are really getting a breakdown of where the customs law is as of now within Sri Lanka and what the laymen need to be aware of. Stay with us on Law Line and Liberty. Right, welcome back to Law Line and Liberty. We are in conversation with Attorney-at-law Tivanka Ekaratne. I think the first segment we really covered on the principal areas that people need to be aware of, and I think it was a very good breakdown for all of our viewers pertaining to what they need to know when it comes to this field. Just stemming out from what we discussed within our first segment, the contentious issue as in what most people complain and what most people have a entire public conversation is about the customs duty and how it's applied, how the entire tariff structure works, and a number of key areas that we need to get clarifications from you on. Now, firstly, I want to keep it brief and ask you from the ordinance, what are the key sections that deal with customs duty per se, what are the ways they deal with it, and I think we can build on that afterwards.
Yes, Dhanandu. Generally, customs duty is levied as per the value of the goods. That is in general. However, there had been instances like in vehicles and all, depending on the engine capacity, etc., etc. But in the general form, when the goods arrive from one country to another, say for example, if goods come from another country, Sri Lanka, say you have paid $90 for that particular good. When the goods arrive at the port of Colombo, if that product, a similar products of that nature and of best quality, if the price in Sri Lanka is $100, that is the value that would be taken by Sri Lanka Customs in order to calculate the necessary duties and the levies.
This is value in Sri Lanka.
Value in Sri Lanka.
Right.
There is a tariff guide published every year by the Sri Lanka Customs, which is a comprehensive piece of I would say a book or a CD, in which it gives the specific code, you call it HS code, and the specification, description of the good and the taxes that is levied upon each and every good. However, the value is the most important factor when it is determined. Apart from that, under section 10 of the Customs Ordinance, Parliament may from time to time alter the customs duty leviable on any import or export. Apart from that, the minister, with the approval of the cabinet, can impose levy a surcharge on the customs duty payable. So people must know that they have to declare the correct value of the goods, and based on that value only everything falls in next. In Sri Lanka Customs, when you submit a customs declaration, that is the document that you fill with regard to your description and your HS code and the value and etc., there is a person by the name of appraiser who will go through the documents and find out whether the price, the value that has been declared to Sri Lanka Customs is correct. If the value is not correct, he will uplift the value. And he will say this is not the value and this is the value, and thereafter based on that value the customs duty and the other levies will come into operation, which the importer has to pay in order to get the goods released from the Sri Lanka Customs.
Right. Hearing what you have to mention, there are some clarification I want to make. Now, in the case of an appraiser, that would also be a customs officer, if I'm not mistaken.
Yes, it is a customs officer who will be usually in the rank of Assistant Superintendent of Customs or a Superintendent of Customs.
Right. Now, just to get into more specifics, what is the Parliament's duty in that scenario in terms of the identification or the classification of HS codes? This is something that is happening internally within the customs, that they would have to like go over, audit the entire thing, understand what the current trends are for products and then release the HS codes, or is it something the government would decide on behalf of the customs?
It is the government who will decide on behalf of the customs, and they will go into each and every detail and the government policies, and this tariff guide which I mentioned a little while ago is only a guidance to the importers, so that they will have some idea as to, if you import this particular product, this is the amount of tax and these are the amount of other leviables that you are supposed to pay to Sri Lanka Customs. It is always the government who will impose the taxes and the Parliament who will approve, and thereafter it will become the law of the country.
Based on what you're mentioning, Mr. Tivanka, I want to get a clarification on the undervaluation aspect now. This is what I was mentioning, it is the key area that people would have an issue with, as in I think the contentions between customs officers and exporters and importers will also arise there. I just want to get a clarification on how that occurs, as in is it possible for me to call it a crime in that scenario, or how the identification happens there, and when it does, what is the process from a customs officer's point of view to initiate a sort of investigation or an issue there? Because what I gather from what you're mentioning is that it is up to the discretion of the customs officer in those scenarios to identify whether this is undervalued or not. If you can give us a small explanation there.
Yes, that is directly a valuation of the provisions of the customs ordinance, undervaluation. And when you take the offences, that would be one of the main offences that is committed in Sri Lanka, given the fact that the competition in the market. So when you take two importers, those two will compete each other, and if they are managed to bring down the particular good at even slightly lesser than the other person, then you will have your bigger profit, and then you will succeed in the business. So most of the importers, they tend to undervalue. They don't declare the correct value to Sri Lanka Customs. So in such a case, the customs officers will always, in the event if the appraiser did not find that undervaluation, thereafter they will always initiate an investigation. Undervaluation is dealt in section 58 of the customs ordinance. So anyone who intends to defraud such duties, who is knowingly concerned under section 129 of the customs ordinance, will be liable to forfeit either treble the value of the goods and or to a penalty of 100,000.
Right.
Yes, I think that.
That answers the question. I think that will be the penalty aspect in all of this. What are the other areas in terms of duty, as in customs duty, that is not either paid properly or if there is a certain issue in the transaction, that is governed under the ordinance? As in, my question there lies, because is it only the HS codes that decide the specific duty or the tariff, the specific duty that needs to be paid, and thereby that will be the only charge on said product, or are there other sort of charges that people need to be aware of?
Apart from undervaluation, there are other violations that is more commonly committed by importers. That is misdescription, non-declaration, making counterfeit documents, etc.
Okay. If I may ask this question also, now since we are in the question of duty, we see it's not only the import-export aspect that is in question here. We see that people would in general bring either foreign currency or certain products once they come through immigration into the country. And there also we see the customs officer is the individual that is in charge of the commodities that move in and out of the country. I want to ask you, in that scenario, if there is a declaration that needs to take place, I believe there are certain channels that people need to go through. How does, in the event there is, if you can explain to us, in the event there is non-declaration of a product that needs to be declared, what is the penalty or what is the sort of course of action the customs takes? And secondly, in the event there is a declaration, is there duty or of sorts to be paid at that point itself? What is the sort of other documentation that is required before that? If you can explain all of that.
any person coming down to Sri Lanka is specifically advised at the Sri Lanka Customs arrival to get a form, a declaration form, and declare what exactly you are bringing down.
Right.
With regard to currency, foreign currency, I would say anything more than 10,000 US dollars, although it is said 15,000 now, equivalent to US dollars 10,000, better to take a declaration form and fill it and declare to Sri Lanka Customs.
Right.
Only if there's nothing to declare, this is only with regard to currency, if there's any other products that need to be declared, it is always advisable to declare it to Sri Lanka Customs, and you come through that channel and they will check your baggages and the declaration form, and if they are tallying, they will always allow you to go. If there is a duty that is to be paid, at that point of time, you will be said that this amount has to be paid, and once you pay that, you can come out with the goods.
Right.
And if there's nothing to declare, then only it is advisable to come to the green channel.
Right.
What will happen is, if you don't declare, for example, the specific currency, you are bringing anything more than the specified currency. If you don't declare, if you are detected by the Sri Lanka Customs officials, it is always liable to be forfeited.
Okay.
And top of that, there can be also a penalty that would be imposed.
Right. So I think that gives a clarification on that. I want to ask about the other criminal elements, about the illegal imports and everything, where we can really take a separate segment on, because what we spoke about till now is mostly on the revenue aspect of the customs. There is a social protection aspect the customs is also playing, which I really want to get a breakdown from you on. We'll continue this discussion with Mr. Tivanka Ekaratne. You are watching Law, Land and Liberty. Right, welcome back to Law, Land and Liberty. We are in a very interesting conversation with Attorney-at-law Tivanka Ekaratne pertaining to the fundamental laws that govern customs duty in terms of the revenue aspect and in terms of the social protection aspect that the customs, as an institution, it serves. And this specific area I want to dedicate to that latter aspect of everything. Now, when you say customs officer, in general, the perception of that person is someone who goes over your luggage to discover maybe some illegal import, which is the general perception the public has as what the customs officer's role is. Just to talk a bit more about that aspect, if we can start off by mentioning within the ordinance, what are the areas that govern this, as in what areas empower the customs officer in doing those specific activities? And secondly, if we can talk about the investigation aspect, if you can give us an explanation there, because it's from the point of which authorities are allowed to have an investigation, whether the defense is allowed their own form of investigation, which is what generally happens in a criminal case. What are the nuances that are available there?
Customs officers have a vast powers and authority given to them, same as, or I would say more than a police officer. Go into any section with regard to any violation, they can raid a place, they can take possession, whatever the documentation, they can get the laptops or phone, whatever the related to the investigation, and they have powers even to keep them in custody with the sanction of the magistrate's court and investigate, question them. However, if after a certain point they feel that they should be kept further, then definitely they should be produced before the magistrate under section 127 of the customs ordinance, and they can obtain orders of remand. Although people think they are only confined to certain things, it is not. If you take, for example, drugs, there are so many offences relating to drugs that take place via Sri Lanka Customs. What they will do is, they will initiate investigations and they will do investigations to a certain extent, and thereafter they will get the assistance of the criminal investigation department. And in such a situation, although the initiating officers would be Sri Lanka Customs, thereafter it will be handed over to, as I said, by the criminal investigation department, and they will be produced to the magistrate and under section 136B of the Code of Criminal Procedure Code, and thereafter the action will follow. In such an instance, if the matter is indicted in the High Court, it would be always the customs officers who will first be called as the prosecution witness number 1 or 2 or whoever, and their work would be to a greater extent, as I just explained.
Yeah. If you can, based on the experiences that you have had, and I know that you have also had to represent certain clients in these specific areas as well, in terms of either drugs being brought into the country and that entire investigation aspect, where do you think there are more contentious elements, that there are issues of clarity? Because down the next segment we're going to talk a bit about reforms and remedies that are available. What areas would you like to sort of iron out and mention, okay, these are now, when we talk about the general criminal law within a country, if there is a certain amount of drugs that is found, that is discovered with a person, that individual will either be held in remand or without sort of any form of preliminary investigation. Are there certain aspects like that which you can explain to the general public about, these are certain sensitive sort of areas that the customs has sole authority over, where they have to sort of like govern, they have to like look into? And in terms of detention, like if an individual is brought in and there is a suspect or there is a suspicion that is arisen, what exactly is the customs authority that is awarded to a customs officer to detain an individual?
They have all the authority as much as the police or the CID officers have.
Right.
But only thing is, if it's going outside their purview, they will always detain, get the initial statement from them, and if the goods can be found, they will take them into their possession, and thereafter most probably they will hand it over to criminal investigations department. Otherwise there would be a clash between the organizations. Right. But of course they have the whole authority and the power to do so.
Right. If I just to zoom out of this conversation and say, if the general public has certain information with regards to some either drugs or something that is illegal being brought into the country, what authorities should they reach out to? Is it because in general, within this program, what we talk about is there's a lot of burden being put on the police investigation, as in the police department. Is there an arm within the customs organization, the institution, to really reach out to the general public and work with them in terms of identifying these illegal either inflows or outflows from a country? What exactly can you, in terms of like what the layman can be aware of?
Yes, Danito, there is a special department at Sri Lanka Customs where all information is gathered. Any citizen can just give a telephone call or send a letter and give the information to Sri Lanka Customs, and they will always keep the that information as safe, and the informant will never be divulged.
Right.
And once the inquiry and the investigations are completed, if there's a penalty imposed on drugs or any other thing, they will always be entitled to a reward share. That is an important factor in the customs ordinance. Right. Even if there's any smuggling that is taking place, if one is aware about it, you can always contact Sri Lanka Customs. They are a special unit, Central Investigation Unit. You can give your information and they will record your name and ID number and things, etc. And upon the completion of the investigations and the penalties paid, you will be notified, and it will always also be published in the customs notice board saying that this inquiry number, please come forward and receive your reward share. So there are people who have been benefiting in big way,
right,
in being part and parcel of this process.
Right. I think that also gives a certain amount of clarity about what the incentive process that is awarded by the customs. I want to take a very short break and we can discuss the remedies and the reforms. I think in terms of general law, we have covered the things that the layman would really like have a lot of questions on. We'll take a very short break. We are in conversation with Attorney-at-law Tivanka Ekaratne. We have just covered multiple segments on the basic fundamentals of customs law, and we'll talk about the remedies and potential reforms towards the future. Stay with us on Law Line and Liberty. Alright, welcome back to Law, Line and Liberty. We are in conversation with Attorney-at-law Tivanka Ekaratne, and this will be our last segment where we talk a bit about the potential reforms and the areas of remedies. Now, my first question, Mr. Tivanka, I think elaborating on multiple things that I think for the layman that wouldn't have been clearer before, which you have really explained to us. One area is when you talk from the defendant side. I think most of the segments we really spoke from the customs officers' angle of all of this. We'll just touch on the areas of remedies that are available in the areas that we were just talking about for the defense in this scenario. And then if we can just move into reforms as well. How do you exactly approach the issue of remedies? What sections within the ordinance should we be aware of when it comes to the question of remedies? Because one thing that was clear to us during this discussion is the customs officer, then the Director General of Customs, and then the Minister holds a lot of authority in terms of governing and mediating all of these issues. And it is in the event of a penalty not being paid that it will then divert into the traditional court system, which I personally think would be a very good thing, because we are now moving towards a more the arbitration sort of aspect where there is more, we see a much more efficient process where there is this individual's approach where the arbitrator is involved, which is kind of like the case when it comes to customs, which is what I'm gathering. What are the remedies that are involved in this section? What can you really explain in that area?
Danidu, firstly, you must know the remedy which is provided in the customs ordinance. If the goods are forfeited, then you are supposed to go to the district court under section 154 and 55 of the customs ordinance, and when you do that, you have to give notice, 30 days notice, and thereafter within that stipulated period you are supposed to file action and contest the forfeiture. And in all other cases, mostly as general practitioners, what we would do is, or advise to do is, we go to the Court of Appeal by way of writs of certiorari, mandamus, and prohibition. The advantage we have when we go to the Court of Appeal is, initially we will get an interim order. Say for example, if there is a penalty imposed against your client, and when you present your case, initially you ask for an enjoining order, restraining order, preventing the execution of the order. So that is the most important thing, because mostly what the customs will do is, when there is a penalty imposed, in the recovery process, they will tend to arrest the particular parties. So you get the interim order preventing them from arresting. Secondly, you will get an interim order preventing the execution of the particular order that has been given. So you can't arrest, plus you can't recover whatever the money is penalty imposed until the final determination or until a certain specified time. And thereafter, what you do is, once the state comes and files the objection, you will also file, then it will go to the main inquiry, and then after the case, you can ask for a certiorari, which is a quashing of the inquiring order of the inquiring officer. So depending on the bias, depending on if the case has not been established properly, if there is evidence that was reduced at the inquiry is not proper, and if due to various things, and there are certain instances where certain officers who should not be part and parcel of the prosecution can be involved. And even the inquiring officer, if there is a component of bias, and if that objection has been taken at the initial stage, where there is a famous case where at the inception, where this case was initiated, the defense counsel took up the objection that the inquiring officer is biased. However, it was overruled by the inquiring officer and went ahead. And once the order was delivered, the case was referred to the Court of Appeal, and based on that, the Court of Appeal quashed the order of the inquiring officer.
Right.
That is the usual format, the remedies which you would advise.
Yeah, just to ask a question on that, I think I just had two issues that I want to clarify with you. The question of bias of an inquiring officer, how does it really come about? Is it based on their affiliation to something with regards to being heard, or how does an inquiring officer recuse themselves from a case? What are the grounds there, if you can just give a small elaboration?
At the customs inquiry, it is always the rules of natural justice which should be adhered to. There are a series of judgments. If rules of natural justice has not been adhered to, the court has held with the defense. And at the customs inquiry, before the commencement, all customs inquiring officers will have to ask from the defense that I am holding this inquiry under section 8(1) of the customs ordinance, and whether there is any objection in me holding the inquiry. At that point, either the suspect or the attorney at law who is representing the suspect has to take up this objection and make sure that it is recorded, so that at a later stage, if there is any element of bias is being taken, you can always take up that matter at a higher forum.
Right. Just before we move into the issues of reforms, I want to ask one more question on this area. The remedies that you are mentioning, that the use of that process, as in I think what you mentioned was the inquiring officer's judgment, let's say, was put into question at the Court of Appeal. What is the process of going or appealing towards the extent of the Director General, or then moving towards the Minister? Does that happen parallel or separate to this entire process? Because I think that if you can give that clarity, that will be important to us. Because what I'm understanding is, once an inquiry officer has given a specific judgment, the individuals or the defense that is part of it can go to the court of appeal or a specific court in that regards, or should they be moving towards the Director General? What should be their course of action there?
Usually, Dhananjay, what happens in practice is, say for example, there is an inquiry and a penalty is imposed. Say they have imposed double the value of the offence that has been committed, and they will always mitigate it slightly lower, or to a certain extent they will mitigate it. The inquiring officer himself, because the inquiring officer will be appointed by the powers vested upon the Director General of Customs. It is basically a delegation of powers.
Yeah.
So he will mitigate the penalty that he has imposed using section 163. So at the when you take the order of the inquiring officer, if section 163 is there, then you cannot go back to the Director General of Customs and lodge an appeal. In that instance, what we can do is, you can always go to the Minister under section 164. However, that process usually takes time. And in most of the instances, the remedy that you are getting by way of appealing to the Honourable Minister, you hardly get the relief.
Right. Why is that process more time consuming than going to courts in that scenario, just on a practical level? Yes. That is what you have experienced.
The importance in going to court is, one thing is, you know what your case is.
Right.
You know what you are going to get at the end of the case. And you get an interim relief. That is the most important part. By just going to the Minister under section 164 of the Customs Ordinance, there is no any stay.
Right.
There had been certain instances where certain attorneys have advised them to go to the Minister, as correctly said in the Customs Ordinance. However, while the appeal is pending with the Minister, they have initiated actions to recover, the Customs have to recover and or to arrest. So the danger here is, Danidu, if the Customs officers arrest you at that stage, when the order had been delivered, they will always file action in the magistrate courts under section 146 of the Customs Ordinance. If they do that, any importation which is exceeding more than 1 million, the magistrate does not have powers. It is only the High Court under 127C of the Customs Ordinance who has power to grant bail, and even that is on exceptional circumstances.
Right.
So it is more likely that if you don't recourse to any action immediately, like a by a Court of Appeal action or whatever, that you will get arrested and will be remanded. If you are remanded, then you will have to stay in remand for some time until you get a relief.
Right. I think we spent a little bit of time on the remedies, and we are running short of time, so I just want to get your brief understanding of the potential reforms based on your practice. What are the key areas that we really need to look at moving forward from this point onwards?
I would say I would like to speak on two main areas. One thing is customs inquiry. That is one very important key area. Although initially I said the customs ordinance is a beautiful piece of legislation which covers almost all the areas except the customs inquiry procedure.
Yeah.
So there is no any procedure, customs inquiry procedure, that is laid down in the customs ordinance. So there is a necessity that procedure, like in criminal procedure code and civil procedure code, a procedure to be laid down as regards to the customs ordinance, so that people will know, litigants will know, attorneys will know that it has to go through this procedure. That is one important thing. So there had been committees who had been appointed by previous governments, which I happened to work in the main committee as a 3-member panel. But after we presented all the proposals, thereafter it never came into action. So that is one area that needs reforms, immediate reforms. The other area is the law with regard to bail. 127C, that is that was implemented in 1991. It says any importation which exceeds the value of 1 million.
Yeah.
So today's context, anyone would know any importation or exportation would mostly surpass that amount, more than 1 million. So in such an instance, it is only the High Court who can grant bail on exceptional circumstances. So this has to be changed. It has to be amended or reformed. I think immediately it has to take place.
Right. I think in terms of the reforms aspect, very interesting sort of like suggestions. And as we have noticed, there were multiple committees that were established for multiple areas within the law, and like many people I've had the good fortune of having the conversation with also. So hopefully this area, which is quite pertinent to Sri Lanka moving forward in terms of how it's the business, the ease of doing business within a country is really considered. I hope the relevant authorities will take into account what Mr. Tivanka, the Attorney-at-law Tivanka Ekaratne has mentioned. We'll have to stop our discussion there, unfortunately, due to time constraints, but I think a very fruitful discussion in terms of how the layman can understand this specific area that was somewhat alien to a lot of people, but now I think even personally I've gotten a lot of clarifications throughout this segment. Thank you for joining us, Attorney-at-law Tivanka Ekaratne, the former president of the Colombo Law Society and leading practitioner within the field of customs law, for taking the time today to speak to us.
Thank you, Daniel, for inviting me.
All right. Sri Lanka is in an important junction in its history where trade plays a pivotal role. The recovery of Sri Lanka's economy will depend on the ease of individuals and multilaterals to trade, thereby exchanging goods and services without unnecessary intervention. Chinese Premier Li Keqiang once addressed the World Economic Forum and stated that the fundamental principles of free trade should be upheld, the interests and concerns of all parties be accommodated, and the broadest possible consensus on reform be built up. Taking a multilateralist approach will not solve any problems. That is all from us here at Law, Land and Liberty. If you had missed today's program, you can rewatch the entire episode on our YouTube channel, youtube.com/otherthanenglish. I'm Dalil Tanwasan. Have a great night.